Hello, my name is Ian Larkins of Radius Law and welcome to our commercial bulletin in association with LexisNexis. A recent dispute between Costco supermarkets and one of its supermarket customers raised a question about the liability cap in the contract. Costco had sued the customer for not paying its invoices. The customer counterclaimed for lost profits caused by a change in Costco's business model. Now, the liability clause stated, in respect of all acts, omissions, events and occurrences, whether arising out of any tortious act, breach of contract or statutory duty, or otherwise arising, is limited to 5 times the service charge paid in the previous year. Now, there had not been any service charge, so the first instance court ruled that the maximum liability of both parties was 0. The High Court disagreed. Costco's claim was for non-payment of goods, which at law is considered a primary obligation, rather than a claim for damages for breach of contract, a secondary obligation. The High Court ruled that only the clearest of wording would enable liability to be capped at 0 for a primary obligation. The words were not clear in this instance, and therefore Costco could recover its debt. Companies House has launched an urgent review after it was identified that there had been over 800 erroneous filings on 190 companies, raising fears over a sophisticated fraud targeted at banks. The erroneous filings wrongly showed that charges had been released. The attack exposed the lack of controls at Companies House for discharging charge registrations. Now, whilst the removal of the charge registrations is unlikely to affect the underlying agreements, usually with a bank, it could mislead third parties and potentially affect the lender's priority in the case of a borrower's insolvency. Now, as we've previously reported, the new Economic Crime and Corporate Transparency Act will require Companies House to improve its processes for identification and verification of its register. But the timescale on most of these changes has not yet been finalised to allow time for Companies House to implement the necessary systems changes. We have previously reported on the Competition and Markets Authority, the CMA's investigation concerning manipulative online selling practices into Emma Sleep in our September bulletin. The CMA has now turned its attention to another mattress company, Simba Sleep, for very similar concerns, including the use of countdown clocks to pressure snap purchasing decisions and alleged misleading price comparisons, e.g. the use of was now prices to suggest a higher everyday price that the product is usually sold at. The Advertising Standards Agency has already made a ruling against the firm, so we anticipate the CMA will also rule that they need to change their practices. If the CMA cannot resolve by Simba agreeing to undertakings, it will need to take court action. Businesses should note that the CMA will soon be able to impose fines directly once the Digital Markets, Competition and Consumers Bill is implemented. The Supreme Court has recently ruled against Amazon for infringing the UK trademark Beverly Hills Polo Club that's owned by Lifestyle. Amazon accepted that Lifestyle owned the UK trademark, but said that there was no infringement because the mark was used on its US.com website. The Supreme Court, however, sided with Lifestyle. It stated that it was obvious that the website was targeting UK customers because it had references to deliver to the UK and other similar statements. Accordingly, Amazon's use of the marks infringed Lifestyle UK's trademark. Every day, consumers are clicking to accept terms in online contracts, but is that a valid way of incorporating terms into such contracts? Should the consumer be required to scroll through the terms before accepting? These were some of the issues considered by the Court of Appeal in a recent case. The Court of Appeal, agreeing with an earlier High Court decision, ruled that provided there are no terms that are unusual or unfair, then clicking to accept without scrolling through the terms is a valid way of incorporating the terms into consumer contracts. The Court has recommended that the Law Commission reviews whether the law needs to be reformed to protect consumers that mostly accept terms without reading them. The Companies Act requires directors to have regard to the impact of the company's operations on the environment, and we are seeing more legal actions against companies and directors alleging that they have failed in this duty. We have previously reported on Client Earth's action against Shell's directors. A recent report by the Commonwealth Climate and Law Initiative recommends that directors do more to consider nature-related risks and take action. These words reflect the comments of Lord Sales, Justice of the Supreme Court, who has said, "There is much force in the view that directors may and increasingly must take into account and accord significant weight to climate change in their decision making." We have previously reported on the Green Claims Code, which sets out prescriptive rules on organisations making green claims, particularly that they must be substantiated. The fashion industry has been under the spotlight of the Competition and Markets Authority, the CMA, following investigations by the CMA. ASOS, Boohoo and Asda have signed undertakings that the CMA has hailed landmark changes to their approach to making environmental claims. In March, the CMA published an open letter to fashion retailers warning that businesses should familiarise themselves with the Green Claims Code and with the commitments in the undertakings and take all necessary steps to ensure that any environmental claims that they make comply with consumer protection law. Now, inevitably, the CMA will turn its attention to other sectors soon, so it's important that all businesses learn from these early actions in the fashion industry. There is a stark difference between the UK and EU approach to AI. The EU is legislating with the AI Act. There is a staggered implementation and it will be 3 years before it's fully enforced. The regulation will reflect 4 risk levels: unacceptable, high, limited and minimal. AI systems in the unacceptable category will be banned and must be phased out within 6 months. Non-compliance with the rules will lead to fines ranging from €7.5 million or 1.5% of global turnover to €35 million or 7% of global turnover, depending on the infringement and the size of the company. Now, meanwhile, the UK is adopting a laissez-faire approach. Rather than seeking to regulate AI with comprehensive laws, the UK government will go ahead with adopting non-statutory, contextual, cross-sectorial, principles-based rules. UK businesses should, however, be aware that they may still be caught by the EU laws, which are broadly scoped and will apply to both providers and deployers of in-scope AI systems that are used in or produce an effect in the EU. Recently, the ICO has issued draft guidance on automated decision-making in recruitment, which states that there must be a meaningful human involvement in all recruitment processes, and has issued its 3rd instalment in its generative AI series. The UK Department of Science, Innovation and Technology, DSIT, has also published guidance on responsible use of AI in recruitment and published a responsible AI toolkit. Now, finally, a lesson from abroad. A Canadian court has told Air Canada to refund a customer after its chatbot gave the wrong information. Use of biometric recognition systems entails the processing of special category data, of which is afforded additional protection under the data protection legislation. New Information Commissioner's Office guidance acts as a useful reminder of the unique nature of this data and the inherent risks of using or processing it incorrectly. New product security laws came into force in April. Manufacturers' obligations under the new laws include ensuring pre-installed device passwords are unique or chosen by the user, to inform consumers how long security updates will be provided for, and manufacturers, distributors and importers also have a responsibility to investigate any failure to comply with security requirements and to take action accordingly, to stop supplying products where there is a compliance failure by the manufacturer, and keep records of any compliance failures and investigations for at least 10 years. Businesses that fail to comply with this legislation may be fined up to the greater of £10 million or 4% of worldwide turnover. I'll now hand you over to our expert employment lawyer, Sandra Martins, who will take you through our key employment stories.
In our March Bulletin, we reported that the government published guidance in January on the changes to the working time regulations. the guidance was updated on 1st of April and now confirms that the definition of part-year worker includes term-time only workers who are paid all year round, provided there are periods of at least 1 week when they are not required to work, and the pay they receive is not for the period when they do not work. This means that term-time only workers, such as teaching staff, who are paid an annual salary in 12 equal monthly installments, are part-year workers, and the new rules on accrual and calculation of holiday pay apply to them. The Employment Allocation of Tips Act 2023 will now come into force on 1st of October 2024. The government has published its response to the recent consultation on the draft statutory code of practice on fair and transparent distribution of tips and confirmed the final version of the code subject to parliamentary approval. The Equality and Human Rights Commission, or EHRC, has published an updated toolkit on preventing pregnancy and maternity discrimination at work to reflect the legislative changes which came into effect in April 2024. The toolkit sets out changes employers must make, including ensuring that pregnant women and those on maternity, adoption and shared parental leave are protected from redundancy and are offered suitable alternative roles in a redundancy situation, and given priority for the roles over other employees. And secondly, providing the right to request flexible working from the first day of employment. Employers should update their redundancy and family leave policies to ensure compliance. In Matthews versus CGI IT UK Limited, Mr. Matthews was dismissed due to an irretrievable breakdown in the employment relationship without a formal written warning or being offered a right of appeal. The Employment Appeal Tribunal, EAT, held that the dismissal was not unfair and confirmed that, in exceptional circumstances, an employer's failure to follow procedure may not amount to an unfair dismissal if it can be shown that procedural steps would have made no difference to the outcome. Where a working relationship is broken down, an employer is not required to take all reasonable steps prior to dismissal. CGI had made significant efforts to accommodate Mr. Matthews and rebuild trust, including creating a new role for him, but these were consistently rejected. This was an exceptional case where any further procedural steps, including mediation, would have been futile. Where a disabled employee faces a substantial disadvantage at work compared with a non-disabled employee, employers must make reasonable adjustments or modifications to remove that disadvantage. In Rentokil Initial UK Limited versus Miller, the EAT confirmed that where a disabled employee cannot continue in their present job and they are at risk of imminent dismissal, it can be a reasonable adjustment to give them a trial period in a new suitable role, even if it is not certain that the employee will be successful. That's it for this month. Thank you for tuning in. We have included links to all the documents we referred to today in the written version of this bulletin. But please don't hesitate to reach out to me or any of my colleagues here at Radius Law for more information.